Chief Justice of the United States, John G. Roberts, Jr. Please join me in welcoming Chief Justice Roberts.
Thank you. Thank you.
So, before our conversation, let me tell you a little bit about Chief Justice Roberts. John G. Roberts, Jr. was born in Buffalo, New York, and we're just talking, you were there until you were the age of 9.
Right, right.
And he received an A.B. from Harvard College in 1976 and a J.D. from Harvard Law School in 1979. And actually, one of the things we were talking before that I had not known was that after high school and during a college summer, you worked in the steel mills.
Right. United Steelworkers of America, job class 6, electrical helper.
Do you have a union card?
I had my union card, absolutely. The electrical helper carried around the electrician's toolbox, and every now and then when he wanted a little fun, he would tell you to tighten the screw that was still live. You tighten it and get a nice shock, and never got tired.
And so then you went to Harvard Law School.
Yeah.
And I asked you, when you decided to become a lawyer, and
about the second year of law school. Which was true. I hadn't gone to law school because I wanted to be a lawyer. I wanted to be a historian. And it's a true story, coming out of college, getting close to it, I was being driven from Logan Airport back to school and started talking with the cab driver, and he said, well, what do you do? And I said, oh, I'm a history major at Harvard. He said, I was a history major at Harvard. And I decided, nothing against cab drivers, but, and then law school seemed like a, reasonable alternative, and when I got there, I grew to like it, so.
That's you were the managing editor of the Harvard Law Review.
Uh-huh.
You graduated magna cum laude. And then your first job was you clerked for Judge Henry Friendly on the Second Circuit. What was that like?
Well, to be honest, it was transformational. At that time, in the late 70s, law schools, law profession, I think, was a pretty cynical endeavor. I don't think there were many people who viewed the law as something, some intrinsic value. It was instrumental. And as I said, people had a generally cynical value of it. And I was frankly wondering if I'd made a good choice, not having to want to go there in the first place. And then to spend a year with this remarkable man who, the one thing that was clear is that he looked at the law as something more than just instrumental. I don't want to overplay things, but sort of something with some beautiful interaction as a system of ordering, and then was just brilliant at it. I mean, after arguments, he would sit down in his office, had 2 little legal pads on either side. You'd start writing the opinion, and footnotes or other questions on the other side of the opinion. And then at the end of that, sometimes it took half an hour, sometimes it took a day and a half. He'd give it to the secretary, and she would type it up and then give it to one of the law clerks. And I'd look at it, and it was just again, I don't want to exaggerate, but it was just poetry, and everything sort of fit together, and you could understand how it worked. And the last thing I wanted to do was change it. But he said, no, do what you can with this or that, and look at this point and all that. So, and I started, it really changed my whole view of the law. So that was important step.
I mean, I've always thought Henry Friendly was someone who thought that there were best answers to even the toughest legal questions.
And that's what he wanted. He was very bored with the easy cases, but he wanted the tough ones. And those of you, and you've probably read some of his opinions, can see that it's like an ongoing dialogue. He'll raise some proposition that's important, and then some qualification, and then link it up with something else. And it's also beautifully written.
And then you clerked for then Justice William Rehnquist.
Right.
And how was that like?
It was different in a lot of ways. One, he was a generation. Friendly was almost like 2 generations above me, and Rehnquist was kind of between the 2 of us, so it was a much more, not casual, but it's probably right, and Rehnquist was a casual person anyway. And it was very different approach to law. He was both similarly not cynical, but Rehnquist was very logical. I would say if you read his opinions, you can follow very clearly. You build step by step. Friendly was more sort of flowing. So in terms of learning how to write, it was a great combination. You could see two different styles, and I don't know what people would say my style is, but you can see when some opinions seem to fit a more sort of logical progression, and others seem to involve a little bit more need for more nuance, and you try to, some styles fit different types of cases better. But Justice Rehnquist was just a delight to work for. He was very, very comfortable, very casual. When he was nominated by President Nixon, everybody made fun of the way he looked because he had a real loud tie and the big sideburns. He looked like Buddy Holly. But he was comfortable in his own skin, and it's very interesting. Law clerks, both Judge Friendly's and Justice Rehnquist, were, I think probably as most law clerks are, very loyal to their bosses.
I mean, it is interesting, two very kind of different approaches to legal writing, and I think of them as different approaches to legal analysis. And talking about kind of the different influences as you started your career.
Yeah, I feel very lucky not only to have the clerkships, but from seeing different perspectives and different ways of approaching the job and different work products that come out. It was a good way to start the career.
And then you started working next as an aide to U.S. Attorney General William French Smith. And then you worked in the White House counsel's office when the White House counsel was Fred Fielding during the Reagan administration. Brief period in the private sector, 2 years at Hogan and Hartson, and then you were appointed Principal Deputy Solicitor General by President George H.W. Bush, and lasted for 3 years. And then you returned to Hogan and Hartson in 1993, and then you were there until another President Bush took office. And you were nominated and confirmed for the Court of Appeals, D.C. in 2003, and then in 2000.
Well, you're skipping over some drama. I mean, after I had been nominated for the Court of Appeals previously, and I was nominated on my birthday because they wanted to make it look like I was older. He's been 37 years old for a long time. Well, 20 hours when they that didn't work out. I didn't get a hearing. Some guy named Biden said, "Nah, let's not give him a hearing." And it's interesting because I was naturally disappointed by that, and because then the administrations changed and the nomination lapsed. And didn't really expect. As Rehnquist said, the bus to stop by my place again. But then I shifted back to private practice. But looking back on it, this is in terms of advice. You want your bad luck to be good, because I think if I had been confirmed at that early age, when a vacancy came up on the court, I probably would have had far too much baggage to be considered for it, and no reason to be. But it gave me a chance to move on to private practice and make some money. Always a good objective.
Always a good thing. 2003, nominated for the Court of Appeals. This time as it worked.
Yep, it worked.
And then in 2005 for the Supreme Court. First for the seat that Sandra Day O'Connor was stepping down from, and then Chief Justice Rehnquist died, and you became nominated for Chief Justice.
Right.
Were you surprised?
I was surprised at every step along the way, to be honest with you. I had only been a judge for 2 years, and I didn't have much of a record. It turned out that was an advantage. And it moves very quickly, and then very difficult to have Chief Justice Rehnquist pass away, and it was a period of great trauma. Almost you couldn't really grasp it. I mean, I get the nomination, and then I think it was like a week and a half later, Chief Justice Rehnquist dies, and they had actually postponed my hearings for a while. So, it's the change is being announced. I remember it being like Monday. President Bush talked to me. I went to the White House again Sunday night, and he said, "Well," and I still was wondering what was going to happen with who was going to be the Chief Justice, because I was going to replace Justice O'Connor. And he said, well, would you give any thought to, being the Chief Justice? And I said, no, I haven't. And he said, well, start. And he didn't say, and then we went, he said, they wouldn't want you to be here tomorrow morning. I'm going to sleep on it and all this. And I said, well, fine. And then it was announced that morning. And the next day, I'm carrying Chief Justice Rehnquist's casket up the steps of the court. Extremely emotional time with all this stuff going back and forth. You almost didn't have time to digest it.
I mean, that's a lot.
Yeah, yeah.
So you're confirmed,
Yep.
and you're 50?
Yep. Mm-hmm.
So you're the youngest Chief Justice in 100 years?
200, I think.
200.
Maybe I'm skipping somebody. Well, I bet what you're doing is counting Charles Evans Hughes, but he was already on the court as an associate justice.
Okay, I'm willing to confess error on that. But that is, I researched for this, the youngest Chief Justice.
Well, maybe I.
No, I think you're right.
I don't.
It's on the Supreme Court
Somebody
website.
there can text it or something.
On the Supreme Court website, it says 100 years. So I thought that would be safe, and it turns out.
What says 100?
It does say 100, yeah. You got to get that corrected.
Somebody can do that, right?
So John Jay was 44.
Well, okay, but I mean, life expectancy was much shorter then. So, Marshall was younger.
Marshall was 45.
Yeah.
Yeah, I did my research. But I think that's it. That's it. You're next.
Well, yeah, but that's not 100 years.
That is 200 years.
Just say.
All right. Okay, so emendation, 200 years. All right. Now, to turn on a sadder note, we want to acknowledge the sadness that you and your colleagues who served alongside Justice Souter felt at his passing. And you described him as someone who brought, quote, uncommon wisdom and kindness to a lifetime of public service, end of quote. Would you like to share some of your thoughts on Justice Souter's legacy on the court and on our country, and what lessons you hope lawyers of all backgrounds learn from your late colleague?
Yeah, I argued dozens of cases before him. He was always a fair questioner, sometimes tough. It's not like he was throwing any, lobbing any pitches in, because he wasn't somebody like, a lot of people were on the court, and it's a good thing, sort of really rapid fire. So his questions were always thoughtful, never, designed to embarrass you or to show how, witty or whatever he was. Always direct and substantive and meaningful. You knew they were meaningful to him. And then about 5 years as a colleague. It's interesting. I do think uncommon wisdom but also kindness, which is not always a common combination. He was extremely thoughtful. Any kind of certain tragedy or difficulty in your life, or even pleasant things, you would get a note from him. Beautiful calligraphy type handwriting, and not just sorry for your loss, whatever, but really quite thoughtful. Both sides of the card, and sometimes more about similar experiences in his life, and this and that. I mean, the kind of thing that you save. I mean, I have a nice collection of his things, and very, very thoughtful, and he was very kind in that way. I remember being very surprised when he came in and told me that he was going to leave, to retire. I said, well, David, you're in perfect health, mental acuity. Why would you want to leave? And it was a good lesson in kind of perspective. He said, well, I've been here, almost 20 years. I think I've made, my contribution, and I just want to get back to New Hampshire and back to reading some good books, which is, there aren't many people who would have that kind of perspective, including myself. I wouldn't claim to have that kind of view, but sort of a very good, balanced way of looking at all of it. As we read a letter from the court to a departing colleague, and it was just that, part of it was he wanted to leave, white marble for the White Mountains. And he did. That's what he wanted to do, and so he did it, and kind of certainly very unconventional in that respect.
I mean, that's remarkable. I can't think of anyone else in recent years who's left the court really kind of at the peak of their powers. That's really, I mean, in so many ways, he was a remarkable man.
Very much so, and very, very pleasant to be around. Yeah. We got to know him a little better. Jane and I, our son was going to boarding school in New Hampshire for a while, and we would drive, back and forth and stop whenever we could and have dinner with him. And he had a reputation for being, very cheap. And he was. I think that's something people from New Hampshire pride themselves on. But he would buy dinner, so that was very, very special. We called him. We talked every year on his birthday, September 17th. It's easy to remember because it's Constitution Day, and always had a very, very nice conversation.
That's good. Actually, my wife Allison is here, and our son Liam's birthday is Constitution Day.
Well, there you go.
So it's a great day every way around. Now let me turn to advice. So as legal educators, we strive to teach our students to write and think and research at the highest level. And we also aspire to teach them to conduct themselves in a way that embodies the highest standards of our profession. Are there any particular personal skills or attributes that you think are especially important for young lawyers, like our graduates, to cultivate?
Well, sure. In terms of going out in the profession or entering whatever type of business, I think there's an instinct to make sure people know how much you know. I mean, you want to sort of prove yourself, and someone's asking this or that, and you want something. On the other hand, I found, and I know other people, whether it's other partners in law firms, have been impressed by people who know how to listen. You shouldn't be I shouldn't be, others shouldn't be so anxious to show that, I'm ready to go, I know what I'm doing, but it's more just, what can I do, what is it, particularly with prospective clients or clients, just to sit somebody down and say, okay, now what's the story, what's the problem, whether it is a tenant-landlord problem or a takeover of some subsidiary problem. People don't like to be, okay, this is what you need to do, blah, 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 before you even, it's sort of like being a physician. You don't want to give a diagnosis right away. You want to figure out what the symptoms are. So I think that's a valuable thing to keep in mind. And it might follow from the same thing, and again, in none of this am I suggesting I followed this future advice. You learn from, making mistakes, but I wouldn't be afraid of being naive. You're not supposed to know everything, and it's all right to be, impressed by whatever's in front of you, whether it's where you're working or who the individuals are that come in, or simply somebody who's, has 30 whatever years of experience and is, showing you how to do things. You should, you need, I think, to move away from sort of this inherent skepticism or cynicism, and the people you're dealing with will be impressed by the fact that you seem to understand that you don't know everything already. So I think that would be.
I mean, so listening and being naive. You gave what I think is the best graduating speech that I've ever heard for your son Jack's graduation.
Oh, yeah, yeah.
And you offered some, very valuable advice there. Again, kind of like this, in that it's not what you typically hear in graduation speeches. Could you talk a little bit about that?
Well, first of all, I don't care whether you're, addressing Congress or, the House of Lords or whatever. Nothing is more terrifying than addressing your 8th grade son's graduation. I mean, the worst thing is how, and of course your son is totally embarrassed by the whole thing. But it was short, and so that was good. And I tried to tell them that I thought it would be good for, some bad things to happen to them. To say, that I hope you're lonely from time to time so that you appreciate friendships. Things like that, which seemed to resonate a little bit because even at that young age, these are kids that are going to, have to deal with things. And it's nice to know that when bad things do happen to them, that they should appreciate that, there's a message there. If you're bullied, you should take the lesson from that you don't, bully the younger kids. So I think that's an important, I think for 8th graders it was an important message to get across so that they appreciate that, not every day is going to be great, but you should also understand from that there are lessons there.
But it's like you're not being confirmed the first time you're nominated. I think one of the things that we, try to teach is, or talk about is resilience.
Mm-hmm.
That it's important that, there are inevitably going to be losses in your life. And, to be able to overcome them and be resilient, I think it's crucial.
I think that's right, yeah. And it's never going to be, certainly in your career, whatever you decide to do, it's never going to be a smooth progression. But you need to learn from, the bad things as well as the good things.
So, next advice question. And we have 2 students who asked this question. So, Adrian Jackson and Giovanni Wu, are you here?
Hi.
Okay.
Hi.
Please stand up so you can be recognized.
Hi.
So we endeavor to teach our students about the rule of law, its fundamental role in our constitutional democracy, its complex operations, and at times its fragility. And the class of 2025 now heads off to practice in myriad settings, from civil rights litigation to private equity transactions to cybersecurity regulation. And the question is, what steps can our newly minted lawyers take to strengthen the rule of law?
Well, I think I will take my lead from the person I was first nominated to replace, Justice O'Connor, and one of my current colleagues, Justice Sotomayor, who are very active in something called iCivics. And I think you're talking about strengthening the rule of law. One area where it's most endangered is with young people. By young people, I mean they're focused on high school and 8th grade and things like that. And how many people have really no understanding of what the role of courts are, what the different branches have to do, really even the notion of what law is and what a constitution is. And there are always the opportunities wherever you are. And give Justice Sotomayor a call and she'll tell you where they are if you don't know in your particular area. Now don't do that, just call her office. And you can really learn how to be helpful, whether it's spending an afternoon with the 7th grade class and teaching them how law works, or many, many other things. So there are a lot of opportunities, and I do think you kind of have to start as early as you possibly can, because otherwise it doesn't become part of their understanding of government. I know, when they're cutting classes because they want to add all sorts of other stuff, I mean, certainly civics is the first thing that goes, and I think that's really too bad, and we're developing a situation where a whole group of young people is growing up having no real sense about, how our system of justice works.
Yeah, that's right. And thanks very much for the question, Adrian. In your 2024 year-end report on the federal judiciary, you wrote that criticism comes with the territory for judges and that it can be healthy. So how do you handle criticism of your court or your opinions?
I don't read it. No. First of all, it's a good thing. And I'm not being whatever, I'm sincere. It is a good thing. So long as it's not, trashing the justices, but the court has obviously made mistakes throughout its history, and those should be criticized, so long as it is in terms of the decision, really, and not ad hominem against the justices. I just think that doesn't do any good. And the harshest critics are usually colleagues. If it's the sort of thing where there are dissents. So it's something we're used to. And again, it's a good thing. We're not immune from any criticism, and there are many, many instances in our history where it's been effective over time and leading to a better result.
So staying with kind of the criticism and disagreement, focusing on the court. So our graduates are ending their profession at a time of strong divisions in our society. And you and your colleagues have been known to express strong disagreements from time to time in your written work. Yet by all accounts, you maintain a collegial work environment. So this question comes from Joselina Martins. Okay. Fortunately, this is all being taped, so Joselina will be able to see.
He found something better to do.
So the question is, how do you maintain a collegial work environment?
It's not as hard as you might expect, because you do develop strong relationships. We're nine different people with very different views and different backgrounds, and yet we have to work together on these things that are difficult. You find a way to get along. It's a long job if you're sort of really at each other's throats with bad feelings and stuff like that. It's not a good way to function, and I think we all realize that. We're kind of in it together. And partly that's fortified by the fact that you're, somebody that you're at loggerheads with and, pretty sharp. This is your ally the next case, right? And the sort of normal divisions people focus on, whether it's 5-4, most cases are not that. We're together on cases unanimously more than any other combination. And so you're often working together in a very difficult environment where you really can't share what you're going through with anybody else, whether it's a spouse even or child. And just to take one obvious example, we have a particular case, and what we decide to do will mean whether somebody lives or dies. And if you haven't gone through that with other people, you really don't understand. You share that burden with these other 8 people, and you know that they're experiencing the same sort of challenge and obligation in trying to carry out their responsibility as best they can. And there are little things. Chief Justice Fuller instituted the practice we carry today of shake each other's hand before we go on the bench. And it's amazing how that works, no matter how, I hope the words aren't appropriate, but bitter a disagreement may have been. If the next morning you just sort of have to, take your colleague's hand and look him or her in the eye and say good morning, that does a lot to dissipate it. And you realize, well, it's time to move on to something else, and hopefully we'll, sort of be on the same side then, or if not, maybe it won't be as difficult a case. There have been times in the court's history where that hasn't held up, and there have been really toxic relationships between some members. And I think all of us are committed to making sure that nothing like that happens. So that common commitment, the reality that you're going to be on different sides and on the same sides in different cases, and the obligation that you just have to look people in the eye and, say that that was yesterday, and maybe today will be better. And it comes from life tenure. Little things. If you're sitting next to somebody and you just can't stand the way he or she kind of taps the chair, you're thinking, okay, we'll be here together for 20 years. And, I've got to decide, am I going to tell her to stop doing that? Or am I going to just get over it? Or what? And on a small level, that's kind of the way, across the board. You kind of have to make those decisions and move on. And the fact that we do have to address some very, very difficult things, and we're the only people who are doing it, and we're doing it together, that's just a real bond, no matter where or what. I mean, when you run into a colleague at some event or whatever, I mean, it just is, it's sort of an instinctive connection that we're in this together. He or she, we do something together in a way that nobody else in the government does. So yeah, we disagree a lot, and it's, and the words and the opinions are not, that's not phony. That's what people think. But we have to do it together, and we do it together, and that helps. And I agree, the great wisdom of Justice Louis Brandeis, who said he could do the 12 months worth of work in 10 months, but he couldn't do it in 12 months. And I think that's absolutely right. That break is critical to maintaining a level balance.
I mean, that's remarkable, because I think we all think of Supreme Court justices in isolation or as part of people appointed by the same president. But the human dimension is, is clearly very important. And I love that tradition of shaking hands.
Right. No, it's what Chief Justice Fuller is famous for.
So let me change to a legal doctrine.
Okay.
In recent years, there's been a lot of discussion about the place of stare decisis in the law as an important but not inviolable principle. So what are your thoughts on when to overrule precedent, and are there any misconceptions the public has about it?
Well, I'll start with the last one first. My exact numbers are going to be a little off here because I don't remember them. The Warren Court, I think, overruled an average of 3.2 cases a year. The Berger Court, maybe surprisingly or not, an average of 3.4. The Rehnquist Court was significantly lower at 2.4, per year. The last I looked, the current court's average was 1.8. So the perspective of how many cases are being overruled and all that, I think people have a misunderstanding about how much the current court is overruling precedent. And it is not necessarily a bad thing. I mean, are you happy that Katz overruled Olmsted? Are you happy that Brown overruled Plessy? Of course. So certainly it can be a good thing. You need to have appropriate standards. If you do it willy-nilly, there's no real sense in which law is established. And there's some cases that it just doesn't make sense, even if you think they're bad. I mean, if you have a decision about, well, the way you count the days, the deadline, does include weekends or doesn't include weekends. It doesn't matter what the answer is. It does for the person whose case it is, of course, and so you would never overrule a case like that. And in many cases, it's more important that the case be decided than decided right. But there are other cases where that's obviously not the case, and you have to have significant precedent about when you should overrule precedent. And the one case in which you shouldn't is simply because 5 members of the court think differently than 5 members of the court used to. You need a much more substantial justification for unsettling the law, and that's an important consideration to keep in mind.
So what are the factors that you look at in deciding to overturn precedent?
Well, first of all, how wrong the decision is. I mean, if it's just, it would have come out the other way, or it's something that's a terrible result in an important area, and how necessary it is to the stability. I mean, is that a central ongoing importance, so you don't want that bad effect to continue on into the future? If it's something that comes up only every now and then, that's a different consideration. What the impact is on the stability of law, and what the impact is in keeping what a majority of the court thinks is the wrong decision ongoing.
So now let me turn to your role as a writer of opinions. So I think you have a justifiable reputation as really a great judicial craftsman, that your opinions are incredibly well written. So
Go on. No, I mean, go on.
I'm really, I'm really trying to make up a kind of understating how unique your youth and your tenure was. So you talked a little bit about Judge Friendly and Chief Justice Rehnquist. Is there somebody who was, a model to you with respect to your love of words and writing? And, are there any tips that you could give our graduates about writing?
Well, I can't think of any individual. I think you all probably have the same sense. I mean, the way to learn how to write well is to read a lot, and you will know what's good writing and hopefully absorb some of it. And so that's where I think the ability to write well comes from. Your mind processes the fact you read that and says, I can't figure out what that means, and you learn not to write like that, or that's wonderful, and that's how I know. I mean, it may not, well, I mean, I think of, and again, you're right, I had two very good writers to learn from. I mean, I think of Judge Friendly as, writing like Joseph Conrad. Not that the sentences are for 4 pages, but that they flow really quite beautifully. And even in a technical area, whatever, they do kind of, take you along the right result. And Rehnquist is more like Elmore Leonard, if anybody likes that. It's very, very, very logical steps. But I mean, it's not like you pick up any opinion and it looks like that. I mean, the last ERISA opinion from whichever one I looked at didn't really seem like that. But there are different approaches, and different cases call for different styles of writing. And it's really something that, I mean, if you worry about how it reads as opposed to just the logical structure, you do have to spend a lot of time with it. I mean, you do have to, have a lot of crumpled up pieces of paper. Well, I'm showing my age, I guess. Crumpled up pieces of paper in the trash can, or a lot of keystrokes or whatever, if you're really interested in making it read well. And, some are more interested than others, and there's nothing wrong with that, but I like to do it. So I like to put in the energy to do it.
Is there any justice who you'd single out as a particularly good writer?
I'm sorry?
Any justice throughout history who you think of as a particularly powerful writer who we might keep in mind?
Well, and I don't know if other people will think the same, but Marshall is a surprisingly good writer. I mean, I know Marbury versus Madison goes on forever, but it goes, but you're along for the ride, and it is, I think in many places very eloquent, and a lot of this other stuff was. He's very direct, logical, even for that age. I mean, it's not a lot of legalese. So I think he'd be a good one to read.
It's interesting, your talk also about kind of the personal ties between the justices. When he was Chief Justice, first of all, most of the decisions were unanimous, and they all lived in the same boarding house. So that's
and they drank a lot of Madeira.
Yeah.
Yeah, he was one of the largest importers of Madeira in the country.
Is that right?
Yeah. They complained it's good because of the bad weather, and the water wasn't good, so they had to drink that. And there was the rule in this house they lived in that they would not drink unless the weather was inclement. And Marshall would always send Joseph Story to the window and say, Brother Story, what's the weather like? And he says, well, it's kind of pretty clear. And Marshall said, it's raining somewhere. It's a big country. And they'd say, break out the Madeira. And after a couple of glasses, Marshall would say, well, why don't we do this in that, Marbury case? I'll take care of it. Don't worry. But no, it was, there was the same sort of, probably a deeper bond with them because I don't know if maybe it's too much of being with each other, but they did lived together in the boarding house, spent more of their time riding circuit than sitting in Washington, and almost all the opinions were unanimous. I think there was a holdover where the idea of dissenting really wasn't quite established. And I also think there was a fair bit of, Marshall didn't kind of say, here's what we're going to do. It was more, sitting down together and kind of working it out, and then he just sort of put it on paper.
So, do you have a favorite Chief Justice?
Well, I mean, Marshall's the answer to that question for anybody. I mean, unless you're related to somebody, I guess. But yeah. I mean, his accomplishments are remarkable. He is, I'm happy to defend, the most important figure in American, certainly political history that wasn't a president, and a lot more important than about half the presidents. In terms of, Marbury is such an institutional structure in terms of, I don't have any doubt about what the framers thought, but at the same time, it's not clear that that vision would have been established if it weren't for Marshall. And the tremendous, Rehnquist talks about it a lot in some of his writing. I mean, the single unique original contribution of American political thought to political thought in general was the institution of independent judicial review. I mean, we think of places that have a similar system like England and all that. Well, right, in practice, but, the High Court in England is a committee of the House of Lords. The notion that it's somehow independent from Parliament doesn't make any sense. I mean, they changed that recently with the EU stuff, and I think it's still in effect. They now have a Supreme Court. Before that, they actually didn't. But the idea of an independent judicial entity, a co-equal branch of government, was an extraordinary revolution, and Marshall's determination is that the Constitution is law, and therefore the lawyers on this court are the ones who interpret it, and that's what binds the rest of the government. It was a real revolution, and established at an absolutely critical time, where the notion of how the government was going to function, sort of the Jeffersonian revolution, and the establishment of what we all take for granted of sort of three separate branches of government was really, I don't want to say an open issue, but it wasn't formalized and articulated until Marshall.
So let me follow up on that. So you talked about Chief Justice Rehnquist. So he wrote, quote, "The creation of an independent constitutional court with the authority to declare unconstitutional laws passed by state or federal legislatures, to declare them unconstitutional, is probably the most significant contribution the United States has made to the art of government," end of quote. So what are your thoughts on how the independent federal judiciary has shaped and maintained the rule of law over our nation's history?
Well, I mean, we've had good moments and not so good moments. I mean, the fact that you recognize an institution that's to articulate what, again, is Marshall's word, what the law is, doesn't mean that you're going to get it right all the time, and you may go through periods where you didn't get it right. But the notion that that rule of law governs is the basic proposition. And again, certainly as a matter of theory, but also as a matter of practice, we need to stop and reflect every now and then how rare that is. Certainly rare throughout history and rare in the world today.
And it's invaluable.
Yeah.
So you've been Chief Justice for 20 years. And as you look back, what has surprised you most about how the court of society as a whole has changed over that time?
Well, and again, it's not because of that particular place, although it's a place that I think is going to be dealing with this for a long time. And I think it's an answer most people would give, and that's technology. I mean, it's hard to believe it's 20 years, but I remember clerking for, when I was clerking for Rehnquist, we got the first word processor, and it was huge, and we were just absolutely fascinated about how it would work, and you could change the letters on the scroll, all gathered around it, and the idea of being able to manipulate data the way it can do now, it's hard for those of us of a certain age to kind of always sort of keep up. And now with artificial intelligence, I don't know. I mean, I don't know what the impact on all of you is going to be. I mean, you have these things now they put in, and you go and you're going to be an associate at a law firm. Some partner's going to say, well, give me all the good cases you can have about, contributory negligence that, come out a particular way, and are decided by this. I mean, somebody in the back room is just putting that in and pressing a button, and you know, it's going to take you, if you're a new associate, I don't know how many days to come up with the answer, and now it takes your friend AI 5 minutes. That's going to be a real revolution. And the skill is obviously going to be that you're going to have to develop, probably have, as far as I know, but how to manipulate the artificial intelligence in a way that gives you the most, you know, responsive product. But you know, it's actually not, I mean, the skills to be a good lawyer, they evolve. You know, in Cicero's age, to be a good lawyer, you had to have a good voice, a good strong voice, so they could hear you throughout the, whatever it was, the Curia or something, and he did. You know, and then, you know, in Lincoln's age, you should see, Lincoln argued one argument in the court. When he was a member of Congress, he went down in the basement and argued a case in the Supreme Court. The most mundane issue, it was about the operation of the statute of limitations while the landowner was out of state, and all that. And so we have his notes, and you look at them, first of all, they're exactly like your notes in the first year moot court. He's got a little list of cases here and things over here. And the one thing you notice, it's just beautiful handwriting, almost as good as David Souter's. I mean, it's just beautiful. And that's what lawyers need to do. You're writing the contract, you're writing the title. If you can't read, you know, that's not going to do any good. So then penmanship was an important qualification. When I was in law school, finding the law was a big deal, because you had to go through all these dusty digests, the state cases or federal cases with the keynotes, and go through, and it would be a great thing. I found a case, you know, from the Arkansas Supreme Court that says this or that. That's not a big deal for you now. You all just press a few buttons and you've got every case. But I mean, that's the problem, right? You've got every case, and your skill is kind of trying to figure out, well, which of this vast database makes the most sense. And I don't know enough about it, but what I gather might be the next challenge. Okay, now you've got all this. What technology do you apply to that to figure out, you know, what do you do with these 500 cases, and which ones are important and which ones aren't? I think somebody was showing me the other day that I just really don't like, that they've got this opinion and they say, okay, now do it in the voice of John Roberts. And it comes out and it reads like, yeah, that looks like one of them, and now change it to Justice Kagan, and it's a different thing and all that. But so I think it's a real challenge. I mean, your question being, I don't quite remember it, but I do think it's in terms of the big challenge, and they're different. They're different today than they were when, you know, you and I were coming out of law school. And I do think it strikes me as a real brave new world, and I don't know, once the AI figures out how to do the best presentation of the case, and then you've got other AI things deciding the case, I mean, it's... Yeah. I'm glad I'm not starting out right now, because I don't think I would be very good at it, because I'm not good at the technology. But
so, following on that, in your 2023 year-end report, you wrote about AI and other technological changes and how they might impact the law, but you also reassured judges that machines were not coming for their jobs. Do you still believe that?
You know, I do, in the sense that, I mean, they do that. I mean, you all know better than I do. AI things function as judges in a particular place. They put in this data and figure out, well, 92% of the time when you've got all these variables, this is who wins. But I do think there's still a role for discretion, judgment, and, you know, maybe even programming exactly how something is going to work on some of this stuff. But it's an individual, and, you know, interacting with society at some level, and another individual or individuals who are going to exercise the judicial discretion. And I just don't understand how a machine is going to be able to make those sensitive judgments about whether a particular individual should, you know, go to jail, should prevail. There just seems to me to be too many nuances. Now, maybe I'm just ignorant of how effective the technology can be, but...
So, another technology question. The pandemic required the court to alter the procedures for oral argument. including live streaming the audio feed from the courtroom for the first time. So after the pandemic, you retained the new format. And how has that gone? And do you ever miss the old format?
Well, I'll take them in reverse order. The answer is yes. This was a compromise. Sometimes, you know, I kind of thought when we were done, because you can't have a free-for-all, you know, streaming interaction with lawyers. So we went, okay, Justice so-and-so, now you've got whatever 5 minutes or so with the lawyer, ask whatever you want, and then somebody else, and then somebody else, somebody else. And when we were free of the restraints of COVID and we go back to it, I'm sort of like, well, let's go back to the old way. And some people are saying, you kind of like the new way a little bit. And so we couldn't figure out the new way, the old way, so we compromised by saying, well, let's do both. So that's what we've got now. It makes things longer than usual. You lose a little bit of the free exchange. Maybe it's because, you know, I made a living arguing in that environment. I liked it. I liked the idea that you get different questions coming at you, and if your case was good and you had a sound grasp, you had answers, and that helped make the case. So I don't like sort of one-on-one. It just seems very dull. On the other hand, some of my colleagues like it, and that's, you know, but that's what we're going to do.
Very good. So as we're drawing
because I always try to accommodate my colleagues.
The handshake and
yeah, exactly.
And so as we're drawing to a close, some personal advice. So lawyers and judges tend to work long hours under considerable stress. And what do you do to maintain a healthy work-life balance? And what advice do you have for young lawyers in that regard?
Well, I've found that having children is a good way to maintain a healthy work-life balance because, you know, you want to spend time with them and be interested in what they're doing. You know, my son and daughter's first word was "Dada." Their second word was, "I don't want to be a lawyer." But they've gone in different directions, and I'm happy they did. I mean, you need something outside of your work. And, you know, things like family do that. And resist the temptation to become all consumed, you know, by your work. You know, it's an old saying, you know, about law is a jealous mistress or something like that. Well, you need to make sure you have a broader view of life than thinking that all there is to it is the law. And I certainly hope all of you will appreciate that, and it'll make your life, I think, a lot more enjoyable.
Well, I think that is wonderful advice to close on. Round of applause for the Chief Justice.
Thank you. Thank you very much. I appreciate that.
So we also
Let the record show, my wife was applauding too, so.
So you clearly, what you said resonated with your wife.
Right.
Nice to see you, Jane, who's a graduate of the Law Center. Round of applause for Jane, please. So I have to say, this is really, this is very moving for me. I've been doing this really almost since the start of my deanship. And this is where I conclude. And, you know, just the combination of kind of the wisdom and the thoughtful advice and the sense of humor and the modeling of, you know, how we do the work-life balance is really remarkable. And it's just, it's a privilege for me to be part of this conversation with you. And so we have...
Well, before we end that, Bill, thank you so much for this opportunity, but also for what you've done for the legal community here in Washington and more broadly. It's an extraordinary contribution, and I hope you enjoy what's to come.
Very good. Well,
a round of applause for that.
That was incredible. Thank you. So we have from Georgetown Law Distinguished Lecture to the graduating class presented to John G. Roberts, Jr., Chief Justice of the United States, May 12, 2025. Thank you so much for that wonderful comment at the end, and thank you for an extraordinary conversation. Chief Justice.
Thank you.
Thank you so
Well
much.
done, Fred.
Thank you.
Good job.
Ho messo un attimo qui.